thank you. Yes.
May I seek your Lordship indulgence in mentioning Part 2, item number 5?
Part 2, item 5.
Yes, my lord.
Let me see what is that matter. Part 2, yes. RFA?
Yes, my lord.
Yes.
Lordship, if the matter can be taken up after 1 week.
After 1 week means, okay, after it will be after the next week.
Yes, my lord.
So, you are for?
I'm appearing on behalf of my senior, Mr. Lilfak Oma.
Acha, you are for the petitioner, your
Yes, my
senior?
lord. Appellant, yes, my lord.
Okay, appellant. Okay, item number 5, you write, Ms. So-and-so. Appearing on behalf of Mr.
Lilfak Oma.
Lal Fakoma, counsel for the appellant, prays that there is some personal difficulty
Yes, my
in
lord.
conducting the matter today, and as such she has prayed for a week's time. Prayer is allowed. List the matter after a week. On, you want a date?
No, my lord, any day.
Acha. After a week, on a date to be fixed by the registry.
Obliged. And Lordship,
May I
in
please-
After
Lordship?
2 weeks, you do it after 2 weeks?
Yes, madam.
Okay, after 2 weeks. After a week,
May I
it
please
can come
vote?
up.
yes,
Yes.
Lordship, in item number 10, my senior is the amicus, so has some personal difficulties, so if the matter can be taken up next week.
Next week?
Yes, madam.
Okay. On the prayer made by Ms. So-and-so, appearing on behalf of Mr. Lal Fakama, list the matter next week.
Obliged.
Next week means you do it on 5th.
Yes, my lord.
Can you do it on 5th? Or 6th? Any day, every day is a hearing day, it seems.
Yes, my lord.
6th, okay?
Obliged.
On 6th, fix it on 6th.
May I please, your Lordship?
Yes?
Lordship, I beg to mention item number 6, criminal petition 3. Lordship, I am appearing for respondent on behalf of my senior, Mr. S.K. Medi.
Okay.
Lordship, kindly may fix the matter on 5th of August. He will physically argue the matter on that day, Lordship.
5th August.
5th August.
Acha. This is that matter, right, where the medicines were found to be of not proper quality.
Yes, Lordship.
Acha. Okay, right. Miss, your Miss
R.R. Sekya.
R.N. Sekya submits that Mr. S.K. Medi, appearing for the respondent, CGSC, appearing for the respondent, has some personal difficulty in conducting the matter today, and he has prayed the matter to be taken up on 5th of August. Prayer is allowed. List the matter on 5th. Okay.
Obliged.
You have taken consent from the petitioner side, right?
Yes, yes. Yes, Lordship. Yes, Lordship. We have
Acha.
taken.
To which the counsels for the petitioners has no objection. You write somewhere in between. To which the counsel for the petitioners had no objection. Yes. Yes.
Yes, my lord. Regarding
Obliged.
item number 7 of part 2, my lord.
7 of part 2.
Yes, my lord. As there is some personal difficulties on the side of my senior, Mr. Bilaramyan, my lord, if the matter be taken up next week.
So next week there are so many hearing matters. Let us try, right?
Yes, my lord.
Mr. I forgot your name.
Lomo Maralte.
Huh?
Lomo Maralte.
Lopo Marang Zo.
Ralte.
Okay, write the name and so that I can spell it properly. So and so, appearing on behalf of?
Yes, Mr. Bilaramyan.
Acha. Appearing for counsels for the appellant, prays for some time. Prayer is allowed. List the matter next week.
Obliged, my lord.
May it please, your Lordship. Lordship, I'm appearing on behalf of my senior, Mr. Caesar Ramsana, for item number 3 of the daily list, counsel for the petitioner.
2 and 3 are together. 2, 3 and 4 are together.
Yes,
Yeah.
my lord, all are tagged together. My lord, the counsel for 3, item number 3, he is the first person who has filed the petition.
Acha.
So, my lord, if there is no inconvenience, if it can be taken on 1st of September, for us also it is convenient. All
This-
3 matters.
This is in respect of compensation not paid, right?
Yes, my lord.
For so many years.
Yes, my lord. My lord, that those awards have lapsed.
They have to denote.
Yes,
Again.
re-notify. Yes, my lord. So
But whether that can be done, because I've seen that the lands were already taken possession.
It's Lordship, it's not a question of denotifying. It's a matter regarding taking over the matter under the new Act, 2013 Act,
Ah,
Yes, my lord.
under Section 24.
ah. So that LA gone, so new resettlement
At
compensation.
least there has to be, if there is a direction to that effect, Lordship, reassessment can be made.
Then in that case, whether it can be re-notified or what?
My lord, there is a judgment of Supreme Court that if the award gets lapsed, it would have to restart from Section 4.
Whether that is possible
Justice
in the facts
Bopanna
and-
has delivered that judgment from Supreme Court. That is with me, my lord. But let
That is
us,
from the stage of notification.
yes, from notification.
But whether that will be possible in the facts of the present case?
But that has to be done because there is no other way out. And it might not be in Section 4 of LA Act, it would be under Section 11 of 2013 Act.
Acha.
Because Section 24 of the new Act has said that if something has lapsed prior to coming into effect of 2013 Act, 24 subsection 1, then it would be by virtue of the new Act. So let us go for a
Yeah, that has to be properly heard.
judgment. We would cite at 1st of September.
Okay, fine.
Let's
First-
wait till 1st September.
Okay. So you are making prayer on behalf of?
Mr. Caesar Ramthana, counsel for the petitioner on item number 3.
Acha. So right, Ms. So-and-so, on behalf of Mr.
Caesar Ramthana.
C. Zoram Chana, counsel for the petitioner, submits that there is some personal difficulty you
Yeah,
have.
he's also submitted his leave of absence for this.
Oh, acha. He has some personal difficulty, and that Mr. C. Zoram Soma has also submitted leave of absence. Leave of absence, and as such, she has submitted that adjournment may be granted. The prayer is not objected to by the counsels appearing in the analogous petitions, that is item number 2 and 3.
My lords, I appear for item 4, responding
Acha.
of 5 to 7.
Oh, yes, and Mr.
P. Goswami.
P. Goswami appears for,
two.
appears for respondent number 5 to 7 in 2.
3, item 4,
Item 4. You are for?
the EPI
Acha.
5 to 7.
Respondent number 5.
5 to 7.
5 to 7. Oh, D. Gogoi, okay. P. Goswami appears for respondent number 5 to 7. And in other matters also you are appearing?
I am only,
You are there, your name is there. 5 to 7.
My lord, I am for 2 and 3.
he is for 2 and 3, I am 5 and 7 in 4. Item 2 and 3, he is in.
My lord, if
Oh.
NPCC.
Okay, NPCC. Mr. So-and-so appears for NPCC in item number.
2 and 3.
You pass separate orders in all the items, right? In item number 2, you are there. You are there for the petitioner?
Yes, yes.
Yes. Senior Advocate C. Laljam Juama in item number 2, you write. And in item number 2, you are for?
NPCC.
NPCC is arrayed as?
My lord, 1, 2, 3.
1, 2, 3. Okay. Mr. And so appears for respondent number 1, 2, 3. And 4 is CGSC, right? So Ms. Zairang Sangpui appears for respondent number 3, respondent number 4. And 5 to 7, P. Goswami, you are there?
Yes, my lord, 5, 6 and 7. NPCC.
Oh, yes. And P. Goswami for 5 to 7.
He is passing for.
So there are 7 respondents only.
Yes.
So in item number 3, you write, C is or Mr. Senior Advocate,
Yes, yes.
you are there in 3 as well?
4. I'm not there in 3.
Acha, you are not there in 3. So 3, nobody appears for the petitioner? You are there, huh? So item number 3, you write, 3, on behalf of Zoram Chana. Prays for some time. And same, you are appearing for 1 to 3?
1, 2 and 3.
Same things will appear, will be there.
Not
So-
5, 6 and 7. 1, 2 and 3.
yeah. And P. Goswami for 5 to 7?
No, my lord, 1, 2 and 3. In this it is 1, 2 and 3. In the other one it is 5, 6 and 7.
Acha, okay. So on the prayer made by that, all the matter is adjourned, and the parties have agreed that they would do the matter on 1st of August. Prayer
1st
is
of
allowed.
September.
Of 1st of September. Prayer is allowed. List the matter on 1st of September.
Daily list for admission, item 1.
Your Lordship, this matter is regarding non-payment of the compensation. It's in connection with the word number 4 of 2007, which was pronounced on 12/10/2007. And the government approval for that was obtained on 2/11/2007. And the principal award, that is rupees 643 lakhs 44,856
My
was
lord,
disbursed to the landowners on 3/4/2008.
my lord, CGSC, madam has said that item number 1 has been listed for mediation.
Or is it?
Referral for mediation, however, with the consent of the parties, my lord.
Okay, then let it be referred to the mediation now. What? It is proposed, right? And then you get instructions, both of the parties get instruction on whether they are agreeable.
We have not been informed as to the reference of the matter to mediation.
Acha, acha.
We have not been informed.
Hope both the parties agrees. So take instructions from the clients or you have instructions?
Your
At
Lordship,
present, we don't have.
it may be difficult. May be difficult. They are in far-flung
Okay.
area in a remote corner of the south of Mizoram.
Oh, then you take instructions. I'll give time for 2 weeks. So if it is settled by mediation, good. Right. So, okay, right. Then it is submitted by Ms. Zorang Sampui, the learned CGSC. See, you are a party here, right? Oh, yes. CGSC, that the matter may be referred, may be referred for mediation. The proposal is accepted. No, the proposal, the parties appearing for both the councils appearing for both the parties have also agreed that they would have submitted that they would take instructions from the clients as to whether they are agreeable to refer the case to the mediation. Prayer is allowed. Let the parties get the instructions from the clients.
Let it be within 1 week, Your Lordship.
Okay. And there is some referral thing, right? And there is a big notification.
When
No?
it is this? We are going to.
1 week. I think by today, I think the report was supposed to be given to the Supreme Court. Okay. So both the parties will, get instructions from the clients as to whether the matter would be referred to the mediation, referred for mediation. Prayer is allowed. The parties may take instruction within a week because there is a timeline given by the Honorable Supreme Court in order to send the informations. So the instructions may be taken within a week's period and list the matter on Monday. Or no, not Monday, right? List the matter on 6th. By that time, can you get the instruction?
Yes, yes.
Okay. On 6th of August.
Obliged.
You're blessed.
Item 5.
Five is for orders.
Admission.
Oh, admission. Okay.
Yes, Your Lordship. I'm appearing on behalf of my senior, Mr. Bilaram, for the petitioners, my Lord. And if we may seek further 2 weeks' time to file our rejoinder. If
You have already taken time twice for filing rejoinder,
Yes, my Lord.
right? This time there should not be any excuses because on 11/6 you had taken time to file rejoinder. Even before that, I think.
My Lord, we'll make sure we'll file within 2
Okay.
weeks.
What do you say, Mr. Malhotra?
It's okay.
They had already taken
I
time.
don't, this is the third time they are seeking.
Ah, this is assistant registrar's post,
Yes.
right? Okay. Mr.
Lomo Marat,
Yes, appearing for the petitioner submits that he may be allowed some more time to file his rejoinder affidavit to the affidavit in reply,
yes, my lord.
to the affidavit in opposition.
Yes,
yes.
affidavit in opposition of the respondent.
Rejoinder affidavit, it is noticed that the petitioner had taken time twice for filing the said rejoinder, but the same has not been filed till today, and he has prayed for some more time. However, prayer is allowed. The petitioner should file the rejoinder affidavit within a period of 2 weeks from today without any further delay. List the matter after 2 weeks on a date to be fixed by the registry. Without making, don't take any more time.
Bless me.
For orders, item 7.
My lord, this is a criminal petition. We have filed challenging the discharge order of the learned trial. There's a delay of 56. And my lord, this honorable court has issued standing warrant against the respondent number 2. And the AD card is not yet returned.
No, what standing order?
My lord, respondent number 2 had absconded, my lord, during
It's
the
from
event.
Myanmar.
She's from Myanmar.
Ajay, he was already discharged.
Yes.
Respondents are discharged.
No, before discharging, she already absconded. During at the lower court, my lord.
Acha.
And
The notice was sent.
You had 9/9/2024 only notices were issued.
Yes, 9/9/2024. We had taken steps through registered post. And
Acha.
respondent 1 and 3 has engaged counsel.
Huh.
2,
Yes, 1 and 3 has filed, no, not yet filed an objection
yes,
till date, but otherwise.
I'll be filing, if your lordship permits me, I'll be filing by next week because respondent number 3 is currently stationed at Delhi, so he will be coming back only next week. So I'll be filing by next week, my lord.
Wakalatnama for 2 as well.
No, I have already filed Vakalatma for 1 and 3.
Yeah, 1 and you will file for 2 as well.
No, my lord. 2 has already absconded, my lord. So that is why in the last court date also your lordship has instructed that notice be issued against respondent number 2 who is stationed in Myanmar.
Oh, he is stationed in Myanmar now.
Yes.
Okay, you can take the notice through the police. They will take help from the police from Myanmar.
yes, that is what in the last court date, I think.
Acha, it was already reflected.
Yes, my lord.
Oh, acha, it was my order. She has, it's a lady. And
Yes, ma'am.
Yes.
So there was no order from, there was no, I mean, anything from the
No
police?
return. Yes, not yet.
Okay, what I'll do is let the police give me some report on this order.
Alright.
And as far as 1 and 3 are concerned, you will file objection
Yes,
to
by
the
next week.
condonation petition.
Yes, my lord.
Delay was for how many days? 56 only.
56 days.
Are you really seriously objecting?
Yes, my lord, because this is a state appeal because I was discharged in the lower court, so I do not dare take my chances.
Well, what is the offense about?
NDPS case, section 22C.
NDPS?
Yes, my lord.
Okay.
It's commercial quantity.
Acha, acha. Okay, right. In the last order, dated 11/6/2025, this court had directed the state police to do the needful in serving the notice upon respondent number 2, who is stated to be presently stationed in Myanmar. However, there is no report from the state police. As such, it is further directed that the state police may report on the actions being taken by them without any delay on the next date. As far as respondent number 1 and 3 are concerned, the learned counsel appearing for the said parties prays for some time to file the objection to the present condonation application. Prayer is allowed. List the matter after 2 weeks on a date to be fixed by the registry. They will report it and then, no, we'll give a date so that the police gives the report. So list the matter on 12th of August. 12th of August is a Tuesday.
Yes, madam.
Okay.
Obliged,
And you
madam.
file in the meantime.
Yes, madam.
Mr. So-and-so appearing for respondent number 1 and 3 may file the objection.
No, the report has to be given through the PP or directly to the court.
Directly to the registry, I guess this is what they do.
All right, then we'll have to send a copy to the police, a copy of this order.
Okay, then let them give it to you, you place it. Okay. So this let the copy be served upon the learned PP, and you make some corrections in the first paragraph that police may give the report to the learned PP. Who will place it before the court. Okay.
Obliged, Lordship.
Item 8.
This is also condemnation. Who is appearing here?
Miss Mary is on legs. This is her.
Miss Mary is on legs.
Yes, my lord. My lord, before Miss Mary appears.
Safe custody
Safe
of
custody
the...
of the samples, because my lord, in my case, the samples have reached the FSL after 5 days it was sent. So,
The chain of custody is doubtful.
yes, exactly.
Chain of safe custody.
Yes.
But you will know, of course. You see, on that ground only the conviction will not be vitiated. But what you need is you have to have more grounds. Of course, you have 3-4 grounds. You have taken Malkhana, non-production of Malkhana register. Then 42 violation, then 52 violation. Then what? There was one more, right?
Long gap. The special messenger, my lord.
That delay in sending it to the FSL.
Yes.
As well as the police officer.
Yes.
Conducting the investigation.
The
Of
initial.
course, if we take all the grounds together, then it can be, it can vitiate the conviction.
Yes.
But otherwise, the grounds alone will not. But we'll have to again see. And Malkhana register is not produced, but then the police said that it was kept in the Malkhana with registration number so and so.
Yes. But my
But
lord,
that will not be enough, few the judgment says.
Yes, yes. I have supplied a copy of the
Yes, Mary is here, she
judgment.
can
Yes.
reply, yes. Okay, now give me, he wants to place few more judgments, so after that I'll come back to you. So, okay,
It's
this
a
is on safe custody,
Yes. Relevant para is para 5 and 6, my lord.
paragraph 5 and 6.
Yes, it's a short judgment.
Yes,
May I read, my lord?
yes.
We find, however, that the second aspect on which the High Court has opined calls for no interference. As per the prosecution story, the samples had been removed from the Malkhana on 26/2/1998 and should have been received in the laboratory the very next day. The High Court has accordingly observed that the prosecution had not been able to show as to in whose possession the samples had remained from 26/2/1998 to 9/3/1998.
Here
Yeah.
there are more days than in your case.
In my case, there are 5 days delay. The High Court has also disbelieved the evidence of PW6 and PW9, the former being the Malkhana in charge and the latter being the constable, who had taken the samples to the laboratory to the effect that the samples had been taken out on 9/3/1998 and not on 26/2/1998. The Court has also found that in the absence of any reliable evidence with regard to the authenticity of the letter dated so-and-so, it had to be found that the samples had remained in some unknown custody from 26/2/1998 to 9/3/1998. We must emphasize that in a prosecution relating to the act, the question as to how and where the samples had been stored or as to when they had been dispatched or received in the laboratory is a matter of great importance on account of the huge penalty involved in these matters. The High Court was therefore, in our view, fully justified in holding that the sanctity of the samples had been compromised, which casts a doubt on the prosecution story. We accordingly feel that the judgment of the High Court on the second aspect calls for no interference. The appeal is accordingly dismissed. The respondent is on bail. His bail bond stands discharged.
Acha, what is this? The court found that in absence of reliable evidence with regard to authenticity of the letter dated 26/2, which is that letter? Authenticity
This
of
is
the letter.
the forwarding letter to the FSL.
No,
madam.
acha, has been removed from the Malkhana on 26/2 and should have been received in the laboratory the very next day.
Here, my lord, what the Supreme Court has said is that the samples was in some unknown custody from 26 to
There is no
1998.
evidence,
There's no
right?
evidence at all, my lord.
And the constable and this one was not examined.
They were examined here in this case.
The High Court has also disbelieved
Yes.
the evidence of PW6 and 9.
This is a state appeal, my lord. The trial court had convicted them, but the High Court had acquitted them, and the state had preferred an appeal before the Honorable Apex Court, my lord.
It all depends on the facts actually.
Yes, yes. But even in my case also, my lord, the samples were sent to the FSL on 29/10. But it was received only 5 days later, my lord. And the special messenger who had actually delivered the samples to the FSL was never examined as a witness, my lord. So there is no explanation at all, my lord, regarding the long gap of the special messenger, my lord. And the FSL, the personnel from the FSL was also not examined as a witness also, my lord. So it creates doubts on the...
It is very unusual, like the FSL scientific officer has not been examined, right? In order to say what these contraventions are.
Yes.
Let's see what Mary says.
And
then, okay, this is one.
I've
then.
the other one is, my lord, 2023 SCC online SC 1328. This is regarding non-compliance of section 52A. Relevant paras is from para 13, my lord. May I read, my lord?
Yes.
Notwithstanding the defense set up from the side of the respondent in the instant case, no evidence has been brought on record to the effect that the procedure prescribed under subsections 2, 3, and 4 of section 52A of the NDPS Act was followed while making the seizure and drawing samples, such as preparing the inventory and getting it certified by the magistrate. No evidence has also been brought on record that the samples were drawn in the presence of the magistrate and the list of samples so drawn were certified by the magistrate. The fact that the samples were drawn in the presence of a gazetted officer is not sufficient compliance of a mandate of subsection 2 of section 52A of the NDPS Act. It is an admitted position on record that the samples from the seized substance were drawn by the police in the presence of the gazetted officer and not in the presence of the magistrate. There is no material on record to prove that the magistrate had certified the inventory of the substance seized or of the list of samples so drawn. In Mohanlal's case, the Apex Court, while dealing with Section 52A of the NDPS Act, clearly laid down that it is manifest from the said provision that upon seizure of the contraband, it has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under Section 53, who is obliged to prepare an inventory of the seized contraband and then to make an application to the magistrate for the purposes of getting its correctness certified. It has been further laid down that the samples drawn in the presence of the magistrate and the list thereof on being certified alone would constitute primary evidence for the purposes of the trial. In the absence of any material on record to establish that the samples of the seized contraband were drawn in the presence of the magistrate and that the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the said seized contraband and the samples drawn therefrom would not be a valid piece of primary evidence in the trial. Once there is no primary evidence available, the trial as a whole stands vitiated. Accordingly, we are of the opinion that the failure of the concerned authorities to lead primary evidence vitiates the conviction, and as such, in our opinion, the conviction of the appellant deserves to be set aside. The impugned judgment and order of the High Court as well as the trial court convicting the appellant and sentencing him to so and so is hereby set aside. My Lord, in my present case also, the inventory was admittedly done by before the magistrate. It was also certified by the magistrate, but no photographs were taken, and the list of samples drawn were not done before the magistrate. There is no evidence at all, my Lord. Whether
And even representative sample was not drawn.
yes, no evidence at all, my Lord. Only
Not
the
certified also.
not certified also, and no photographs were taken. Photographs were also not certified by the magistrate. List of samples drawn was not done before the magistrate. There's nothing at all, my Lord. And one more judgment, my Lord. This is a judgment rendered by the Honorable Division Bench of this Honorable Court, my Lord. 2024 for GLT 685. This is also regarding Section 52A, my Lord. I'll read from para 35, my Lord.
Yes.
By the incorporation of subsection 4 of Section 52A of the NDPS Act, with non-obstante clause, an alternative mode for primary evidence has been provided for. As per the mandate contained therein, every court trying an offence under the NDPS Act shall treat the inventory, the photographs of the seized contraband substance taken before the magistrate, and the list of samples drawn in the presence of the magistrate under subsection 2 thereof, and certified by the magistrate as primary evidence in respect of such offence. In view of such alternative mode of presenting primary evidence and non-production of the seized quantities of contraband so and so before the trial court, obligation was clearly cast on the prosecution to produce and exhibit, number 1, the inventory of the seized contraband substance, number 2, the photographs of the seized contraband, which were taken before the magistrate and were seized from the possession of the accused, and number 3, the list of samples drawn before the magistrate under subsection 2 of Section 52A of the NDPS Act, with due certification from the magistrate as primary evidence in order to bring the charge under Section 20 so and so of the NDPS Act home against the accused in this case. The notification dated so and so extracted above had prescribed the form in which the magistrate was required to give the certificate under Section 52A to an inventory. When the documentary evidence and the material exhibits produced during the course of the trial before the learned trial court are looked at, it is found that no inventory of seized contraband substance so and so with certification by the magistrate as per so and so was produced before the trial court by the prosecution. The prosecution neither produced any list of samples drawn as recorded in the proceedings dated so and so with due certification of the magistrate, nor produced the duplicate samples of Exhibit 1 to Exhibit 4 before the trial court. It is pertinent to mention that in the order dated so and so, it was recorded that the correctness of the inventory prepared had received due certification from the magistrate. In the order dated so and so, the magistrate had recorded that the photographs were taken in his presence and he certified them as true. The order dated so and so recorded that the photographs are taken in my presence and certified as true. What is mandated by subsection 2 of Section 52 of the NDPS Act is taking in presence of the magistrate of photographs of seized contraband substance or conveyances and certifying such photographs as true by the magistrate. From the order dated so and so, it is not discernible whether the seized contraband involved in the case had been produced before the magistrate in the proceedings held on so and so. In their testimonies, the prosecution witnesses PW1 and PW3 had deposed to the effect that the exhibited photographs so and so on one part and so on the other part were taken before them in the police station on the date of recovery and seizure of the contraband substance on 21/5/2018. In fact, PW1 had claimed that he was the photographer who took those photographs, exhibit so and so, who were identified by PW1 and PW3 as photographs of the seized contraband. PW1 and PW3 identified the photographs so and so, photographs of the samples taken from the seized contraband by police. On the face of such testimony, the very origin of the material exhibits has come under a cloud. It has been held in Mangilal Supra that when there is non-compliance of Section 52A of the NDPS Act 1985, and where a certificate of a magistrate is lacking, any inventory, photograph, or list of samples would not constitute primary evidence. It has been further held therein that any guidelines issued by a notification in consonance with Section 52A of the NDPS Act has to be followed mandatorily. A notification which the statute has provided for issuance in the official gazette has statutory force, and such a statutory notification is to be treated as a part of the statute. The notification dated so and so was issued in exercise of powers conferred by Section 52A of the NDPS Act, and it was published in the Gazette of India so and so, had statutory force. It is a well-settled proposition that if a manner of doing a particular act is prescribed, then the act must be done in that manner and no other manner. The notification 16/1/2025 mandated preparation and certification of the inventory in a particular manner and in a prescribed format. Absence of any certification by the magistrate of the inventory in the prescribed manner stands in clear violation of the statutory prescribed mode. As per the notification so and so, I will skip this part, madam. I'll jump to para 41. On evaluation of the evidence produced by the prosecution during the course of the trial, it is found that the prosecution had failed to leave primary evidence in the form of the seized contraband, allegedly seized from the possession of the accused. In the absence of any proof regarding disposal of the seized contraband in the manner permissible, non-production of the seized contraband physically before the trial court has given rise to an adverse presumption under Section 114G of the Evidence Act against the prosecution. The prosecution had also failed to bring on record the primary evidence in the form of, number one, the inventory of the seized contraband substance and the list of samples drawn under subsection 2 of Section 52A of the NDPS Act with due certification from the magistrate in the form prescribed before the trial court. There is a clear doubt about the place where the photographs exhibited as so and so were taken in the face of the testimonies of PW1 and PW4 and in absence of certification as true by the magistrate in them. In the absence of primary evidence in the above forms, the other evidence led by the prosecution in the present case as enumerated above could not be termed as valid pieces of primary evidence to prove the charge frame against the accused appellant. Once it is established that the prosecution had failed to lead above primary evidence as a corollary, the trial as a whole stands vitiated. So, my lord, even in my instant case, my lord, there is nothing on record to prove that the list of samples were drawn before the magistrate, and the samples which were sent to the FSL was actually the samples which were the seized articles which were seized from the possession of the appellant, my lord. So, to sum up my submission, my lord, I have placed all my arguments before your lordship. So, my lord, this, yes, my lord, that's it, my lord.
Okay. Okay, Ms. Mary, now he has raised 5 grounds specially, mainly. One is that the Malkhana register was not produced, although it is stated by the police that it was kept in Malkhana with so and so numbers. And then he says that there was a long gap between, when the FSL, the contraband samples were sent to FSL.
Yes.
There was a delay of 5 days in between. The safe custody is not proved. Then he said these are the grounds. He must be having his his written argument. And then he also says about non-compliance of 52A, as he said, photos and a representative sample and list of samples were not certified nor done. Then he also says that 42 initial information was jotted down in the GD, but then the subsequent information where he got the number of the vehicle and all were not written down in GD. And then he says that seizing officer cannot be the investigating.
Yes,
He in
yes.
fact started with the examination.
Yes.
So these are the 5 grounds that he has raised.
Yes.
So please reply to that.
Your Lordship, before I start my arguments, I would like to tender my appreciation for accommodating me to hear this matter today, because the day before yesterday we
It's
suddenly I
okay.
have to leave.
There has to be a coordination with, with the bar and the bench, otherwise things will not work.
I'm deeply grateful. I'm deeply grateful. With respect to the not noting down of the 2 reports, like Your Lordship have already been taken to the facts of the case before. Now, the fact is that the seizing officer have received an information while he was at the police station. Now, GD entry was made, and then he formed a team to conduct the search. So they were divided into 3 teams. They were divided into 3 teams and then detailed into different area. Now, that part is done. It is not argued. But then his contention is that GD entry is not made on the second information, but the fact remains is that they have already left the police station and they were on patrolling. Now, when on patrolling, that section that is not required. Now, the police officer who is authorized, who is duly authorized by the statute, if they are in the police station, Your Lordship knows for sure that they have to do the GD entry, grounds of belief, etc., etc. 42 have to be complied with. But then, if on patrol, by chance, if they get encounter with the criminals, or if by chance they get the report, then how will they go back to the police station to make that technical ground and then let the criminal escape?
No, that he has
is not
said.
that.
He has said that, okay, they need not go back to the police station.
Yes.
But after doing the whatever it was required,
Yes.
they should go and report, right? You have said that.
Yes, my
And
lord,
they
it's-
should go and write it down in
There
the
is
general.
It's in the
nothing-
Karnal Singh judgment, my lord.
Karnal
Even
Singh,
if there's a delay in the information, my lord, the
That
Officer
in
has to-
Karnal Singh's case is that delay in information, there are no 2 reports in that. So it does not touch the fact the fact situation in that case is not the fact, is not the same with the fact situation. In that case, what happened is that delay in writing, it was not written at all. It was not written at all. Information was not written at all. But then in this case, it was written, and after patrol is conducted, then they have received the information. Now, the PW number 1 is the seizing officer. Now, on oath, he have said that. On oath, he was examined, and on cross-examination also, his testimony was not shaken. So, Your Lordship, we cannot say that there is nothing that could vitiate the trial. That is committed, the technical mistake that is committed by the prosecution.
So what you mean is that the subsequent information may not be written because they were out.
They were
not in
out
police
patrolling
station. First
in
one was
search of
written.
the criminal. Yes.
So non-writing of the second one will not vitiate.
Is not crucial. Yes. So as to vitiate the trial.
Otherwise, can you check in the case diary here? They might have written something on the subsequent information
Yes, Your Lordship.
that you can check once.
Yes, I can check.
Date wise, you can get it because the date will be 26/10 only. 26/10/2020. If in the afternoon he has given some, are the records here?
I believe the record is here.
Records here, right? If on, just check the entries on 26/10/2020.
Your Lordship, the case diary, I believe that, let me just check, it's not here.
That's right. Any other records, Mr. Michael Day? Maybe there will be, I want the case diary. Give me the entire file. Case diary I want. What recording? Oh. These are the photocopies of what? Just show me what you wanted.
Okay.
Perhaps that is the GR case record. There is another one at the bottom? No.
Order sheets name
Oh, those are files. No, I'm talking about records.
AFIR David.
Oh. Oh. What about the pink file? Just see this. That is different. Oh, okay. Otherwise, police diary has not come. Case diary has not come.
Case diary is not included in the record, Your Lordship. It seems.
It should come otherwise. In the GR case record, you will not find. Just show me that, whatever you have.
Nothing is there. Sorry. Final report is there. The court daily sheets, daily order sheets is there.
Those are in respect of GR case, but I want the case diary. Only there you can find the entries. Case diary is here, but what about the general diary entries? It's not there. The general diary entries are not there.
Yes, it's not there.
Otherwise, they don't maintain or what?
They used to maintain, but then in some cases when final report is submitted, then they do not
Acha.
submit the GDE.
Okay, then, go ahead then.
Yes. So there is nothing in NDPS, we know that Section 42, etc., is mandatory provision, etc., and then the violation
And
would violate
section
the trial.
42 only provides for writing the initial information
Yes,
in the
yes.
general
There is
diary.
yes, initial information. So if I may take your lordship to Section 52. Let us read again, your lordship.
And in our case, I think 43 will come.
43 will come. Exactly.
My lord, that if that is going to be raised, I have some more citation, because even though the seizure was made in a public place, but it's inside the private car,
Yes.
so that cannot be
But the car
public
was
place.
in transit, it was going.
It was
But
transit,
if
and
the
then
registration of the car is a private car, then that cannot be under
your
section
lordship,
43,
the fact,
my lord.
my learned friend have, okay, if he wants to make the submission, let him finish,
Yes, ma'am.
then I will continue. But then otherwise, the fact is totally different.
Since she has started, you
Yes, my lord,
you
if I may
give
be
it in
liberty
reply.
to reply.
Supposing if they conduct a search inside the private car, then the section 43, section 42 would come into play. But then from the facts, your lordship has been thoroughly taken into the facts of the case. They have stopped the vehicle, they have requested them to go outside. They have seen that the present appellant have kept the seized articles in between his legs, and then they were asked to get out of the car, and then they were asked to open the rucksack, and it contains a Mool gold case. A Mool gold case, inside that there was black polythene. Inside that there are different 20 numbers of packets. So no conduct was searched inside the vehicle. We have to be sure of that. They did not, supposing if they conduct a search of the vehicle, then this would come into play, this section. But then it was a public place. No body search was conducted. No vehicle search was conducted.
Yes, that is, they have admitted.
Yes, they have, it's an admitted fact. It is on oath, and on oath, it is there, on record, black and white. So fact is different. Even if they give hundreds of citations, the fact remains there. Search is not conducted, body search is not conducted, vehicle search is not conducted.
So the case will come under 43 then.
Yes. But I just, since my learned friend is confused, I just want to read out section 42 so as to be sure. Power of entry, search, seizure, and arrest without warrant or authorization. Even though it's not applicable, I will agree. With your permission, Your Lordship. Any such officer, being an officer superior in rank to a peon so-and-so of the Department of Central Excise, Narcotics, Customs, Revenue Intelligence, and other department of the central government, including paramilitary forces. I will skip this, Your Lordship.
If he has reason to believe.
If he has reason to believe from personal knowledge or information given by person and taken down in writing that narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence to the commission of such offense, or any illegally acquired property, or any documents or other articles which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this Act is kept and concealed in any building, conveyance, or enclosed space made between sunrise and sunset.
So concealed in any, kept and concealed in any building,
Yes.
conveyance,
Yes.
or enclosed place. But
Yes.
here the articles were taken out and after that it was checked.
Yes.
So after that it was seized.
And in Proviso 2, Clause 2, where officer takes down any information in writing under subsection 1,
where you are reading?
Clause
Proviso
2.
2.
Clause 2.
Yes. Proviso, oh, clause 2, yes, when an officer.
Your Lordship, before that, provided further that if such officer have reason to believe that a search warrant or authorization cannot be obtained so and so, without affording opportunity for the concealment of evidence
or facility for the escape of the offender, he may enter and search the building, conveyance, and enclosed space at any time before sunrise and sunset after recording grounds of belief. So, Your Lordship, Your Lordship, we can say that in clause 2, where an officer takes down an information in writing under subsection 1 or records ground of belief under proviso thereto, he shall within 72 hours send a copy thereof to his immediate superior. So, Your Lordship, the case is that, like we have already put it before Your Lordship, information was taken down in writing, and then after that they went for patrol, and then after that from the same information he have received the number. At first instance also they have received the information that one car is on the way for committing such so and so. So after that the informer was more specific as to the number of the car. So ground of belief, information report was written down, which is in page number 95. And then after that they have without affording opportunity for escape of an offender, they have stopped, the VLTF has stopped, and then they reached the place, and then after that they have requested them to take out the seized articles from the vehicle, and then so and so on. So, Your Lordship, so this is not crucial in our case, the first ground.
So first, 42 will be applicable only in cases where the articles are concealed in any building, conveyance or enclosed place.
Yes,
right.
Or
So,
private
okay.
property as per the interpretation of the Apex Code.
So, okay, conveyance will be there. Conveyance
Yes,
is
yes.
there, and that will be in our case also. But then again, see subclause 1, clause 1, enter into and search any building, conveyance or place. Enter into and search.
Yes.
Here they did not enter the vehicle,
Yes, enter
they
the
made the people come out.
And they did not conduct search also.
They did not conduct search inside the vehicle. Okay. So, prima facie, it seems 42 will not apply.
Yes. And Your Lordship, in this regard, if I may take Your Lordship kind attention to the page number 14. This is the PW number 2 evidence.
For 1-4.
Yes.
Yes. Now he is the village level task force person who had stopped the car.
Paragraph number 3. There were 2 people inside the vehicle, and the police requested us to witness the search. There was one big rucksack on the floor of the car between the legs of the passenger. The police then told them to get out of the vehicle, and the said bag was also taken out. On the roadside, the police told the accused to open the rucksack, and opening the rucksack, there is a Mughal case, so and so. I have already stated the.
It was, the seizure was done on the roadside.
Yes.
So public place.
Yes. And this is in In the cross-examination in page number 18, it is the fact that we do not conduct search. We only ask the vehicle whether they have vehicle movement permit or not.
Which one? Which serial number you read just now?
Number 3 in the cross-examination. In paragraph number 13 also, I do not see the police conduct bodily search. Then coming into section 43 of the NDPS Act, Your Lordship. Power of seizure and arrest in public place. seized any public place or in transit any narcotic or psychotropic substance or controlled substance, etc.
Any animal or conveyance will also be
Yes.
liable for confiscation.
Yes. So that is my argument to the first point. Now, the second
So
point.
if it is a case under 43, then no GD entry is required to be made.
Yes, required to be made, not required to be made. But then there is this apex court authority wherein they have stated that if information is received at the time when they are in police station, it's mandatory, that's it.
Yes.
Public place, it's
This
different
is of
case.
course chance recovery.
Chance recovery, yes.
When they were there and they saw a vehicle and then
Yes.
43 will mainly come in chance recovery.
In our case also, they have received information, but they do not know which place. So that is why they have formed a team and then separated in 3 groups.
So I think both 42 and 43 will apply in our
Yes,
case.
yes. So coming to 42 and 43, 42 is not violated in our case because GD entry was made, authorization was taken, it was written down, and then in completion of the compliance, then report was sent to the superior authority within the next.
That was also done, right? Within 72 hours?
Yes, yes,
Where is that? Is it made an exhibit?
yes, Your Lordship. Authorization, page number 95 is the information received, 96 is the authorization
That is before the search.
before the search. And Your Lordship, 103. This is in vernacular, translation will be in 108. So on the same date,
103 is the FIR.
108.
Oh,
Your Lordship.
108. Okay.
It's 106, it's in vernacular language. The English translation will be starting from page number 108.
108 is the FIR or what?
Your
No.
Lordship, this is
Not.
report. Sorry, 110.
110. Yes. Yes, submission of report. So this he has sent on. This is still on the date.
20, sorry, it's undated. It's undated.
No, it's there.
Where?
See 12, 11, 21 or something, what? You see on the right side bottom before you, in the same line of yours faithfully.
Your Lordship, this was signed by when it was exhibited before the judge. It was
Perhaps.
signed by the judge on 12/11/2021, but this is not, it's undated. But then this was not at all challenged before the learned trial court. So admittedly, he have, the seizing officer have submitted his report. And let me check the cross-examination.
This is actually a 57 report.
Yes. And yes, Your Lordship, if I may take Your Lordship kind attention to the page number 11, the relevant portion will be in page number 12. This is the examination of the seizing officer. Paragraph number 6. Other than this, we do not conduct body search upon the two accused and searching of another suspected article over the said vehicle. I produce the two accused with seized articles before Nathial Police Station and I submit inquiry report to OC Nathial Police Station. And it was written here, but then in cross-examination, nothing of this such. And in cross-examination, paragraph number 5, I denied that I do not report information I received to the OC Nathial Police Station.
Section, the one that you have shown is under section 57 actually. Within 48 hours they have to report it and they have done it.
Yes. And on the same date for registration of the case, as I have already pointed out in page number 108, this is dated 26/10/2020.
108.
108, yes.
108 is the FIR, right?
Yes,
Or what?
yes. But then, yes. But then
And-
I can make an infer from here.
The last line of the FIR says that I have submitted a report to the OC. Okay. This is on your 42.
Yes. So there is nothing that violates on the part of the action of the seizing officer that violates the mandatory provisions of the NDPS Act in my case. And second, Your Lordship, non-production of malkhana, of course, will be an evidence or to show a chain of evidence. But then, Your Lordship, GD entry is made, and then in the examination by the case IO, he have stated that it was the seized article was kept in a malkhana. So non-production of malkhana register is not, do not per se vitiate the trial. So as to put out all the evidence or put out the trial into ashes. Your Lordship, it is clear that the admission or statement made on oath should not be disbelieved. So it was kept in the malkhana as already pointed out by the case IO in his examination in chief, which is intact in his cross-examination. Nothing is shaken. So non-production of
They did not raise
malkhana.
it before
Yes,
in
yes.
cross-examination.
Yes. Now, with regards to the point number 3, the case IO cannot be the. If I may take Your Lordship kind if I may kindly take Your Lordship attention to 2020 10 SCC 120.
2010 SCC?
2010 SCC 120 Mukesh Singh versus State Narcotic Branch of Delhi.
Oh yes, Mukesh Singh, it is said, right? In fact, the Mohanlal judgment is done away with by Mukesh Singh.
Yes.
Mohanlal says that the seizing cannot be at all by
Yes,
any
yes,
stretch.
yes.
But this one has overruled, I
Yes.
think. That point.
10.5.
10.5.
10.5, para 10.5, page 161.
Yes, yes.
Reasoning is given in the preceding paragraph, but then I'm reading the relevant portion only. Therefore, as such, the NDPS Act do not specifically bar the informant complainant to be an investigator, an officer in charge of police station for the investigation of offences under the NDPS Act. On the contrary, it permits, as observed herein above, to take contrary view with be amending section 53 and the relevant provisions of NDPS Act and or addition something to which is not there, which is not permissible. So now, after that, they have come into reverse burden of proof. But I will stop to that. So, without going further in the investigation, seizing officer being the investigating officer, then that is my answer. And Your Lordship, with regards to section 52A, 52A provides the inventory for disposal.
This has been now clarified in Kashif's case by the Supreme Court. A detailed judgment. What exactly is 52A?
Yes.
52A is only meant for disposal,
Disposal,
of the...
yes. That's my line of argument, disposal. And Your Lordship, my learned friend have, even though it's not included in the paper book, I have seen from the case record that the list of samples drawn before the
even I had seen just now.
Yes.
I mean...
it is there. It was exhibited before the court, but then it was only on preparation of the paper book that thing is left out.
whether it is exhibited.
It's exhibited. It's there in the paper book also, Your Lordship, in page number 128.
Which page?
Page number 27.
27? No, not 27. It's a written
Sorry.
argument.
No, Your Lordship, I'm mistaken. I'll just come to the inventory by the...
But samples, I feel like seeing in the case diary. I mean the records.
I have seen. Your Lordship, if I may take Your Lordship kind attention to page number 121 of the paper book. This is an application made by the inspector concerned for application of correctness
This
of
one we
inventory.
have seen it that time, page number 121, yes.
Yes, application for...
Prayer is made in respect of all the three, but then the subsequent action not taken.
Yes. In page number 122, Your Lordship, certification by magistrate under section 52 so and so. 52,
No, page number?
page 122.
Yes. This is, yes, inventory is okay, certified.
Yes, certified. It's signed by, name is written, Andrew Lashwait. Now, if I may take Your Lordship kind attention to the section 52A of the NDPS Act. Under the clause 2, subclause A. Before subclause A, I'm just skipping the part so as to... In any proceedings under this Act and make application to any magistrate for the purpose
No, wait,
of
wait,
A.
wait, 52A.
52A, subclause 2.
Subsection 2.
Subsection 2, yes. Subsection 2.
Then?
In the last line,
Huh.
in any proceedings under this Act and made application to any magistrate for the purpose of A. Certifying the correctness of the inventory so prepared.
Yes.
And what I would like to stress is or.
Or.
Yes. So what I would like to submit before Your Lordship is that not taking a photograph. Taking a photograph is not mandatory, first of all. It's not mandatory. Certification is crucial. It's like, in my humble opinion, it's like a pension scheme wherein the wife is at the top and then failing which. it can be and or. So we have to, we cannot treat it as correctness, taking photograph, etc. But then we have to read this as or. That means or. It should not be and/or.
It is or.
It is or, yes. And with this regard, may I...
Do you have any judgments on this?
Yes, Your Lordship. 2023, 19 SCC 364.
This is 2319 364. Yes.
SCC 364.
Mangilal. Yes, Mangilal we have gone through, but whether it has reflected something on or. Which paragraph?
Your Lordship, paragraph number 5, 369, page 369.
Yes.
I'll refer to paragraph number 5 and 6. Subsection 2 of the 552A of NDPS mandates a competent officer to prepare an inventory of such narcotic drugs with adequate particulars. This has to be followed through an appropriate application to the magistrate concerned for the purpose of certifying the correctness of inventory, taking relevant photographs in his presence and certifying them as true, or taking withdrawal of samples in his presence with due certification. Such an application can be filed for any one of the aforesaid three purposes. The objective behind this provision...
For any one of the
Yes.
aforesaid three purposes?
Yes.
Okay.
The objective behind this provision is to have an element of supervision of the magistrate over the disposal of seized contraband. Such inventories, photographs, and list of sample drawn with certification by magistrate would constitute a primary evidence. Therefore, when there is no non-compliance of Section 52A of the NDPS Act, where a certification of magistrate is lacking, any inventory, photographs, or list of samples would not constitute primary evidence. The obvious reason behind this provision is to inject fair play in the process of investigation. Section 52A of the NDPS Act is a mandatory rule of evidence which requires the physical presence of magistrate, followed by an order facilitating his approval either for certifying an inventory or for photograph taken apart from the list of sample drawn.
Yes. That is a very valid point. In fact, I didn't know about this or.
So
We were under the impression
the
that all
statute
the
has
three.
to be read between the lines, I believe, sometimes.
Yes.
I have gone through the two reports, Malkana, 52A, and what else?
The long gap. The
5
FSL.
days gap, 5 days
Yes.
gap. Your Lordship, with regards to the 5 days gap, I'm sorry that I do not have the copy of the standing operating procedure 1 of 1988.
89 or 88?
88,
88.
wherein it is stated that 72 hours, within 72 hours, it has to be dispatched. Now, I'm not saying that it is a statute, standing operating procedure is a statute. But then I'm just
But
saying that...
I think those SOPs were later on inducted in these new rules, right?
Yes,
NDPS rules.
yes, inducted.
Everything is in there. All those instructions were incorporated in the rules.
Yes,
Yes.
72 hours. It has to be in
I think
the
it-
1988.
I think whatever you are saying will be in the rules. Then, yes, you say?
Yes. Your Lordship, if I may take Your Lordship kind attention to the page number 12. This is the examination of the PW number 1.
Yes.
seized article was exhibit and shown before the court as exhibit M1, page number 12.
Where? M1?
Yes, exhibit M1, that is
Yes.
seized article. Now, Your Lordship, if I may take Your Lordship kind attention to the exhibits, page number 124. That is sent the letter addressed to the director of FSL, wherein we can see in the next page that numbers of samples in page number 125, numbers of samples and marking on each of them for identification. 18 numbers of polythene packets marked as A1 to A9, B1 to B9. Now, when the search or the examination was conducted, description of exhibits in page number 128. It's A to 9, B1 to B9. So what I'm trying to say is that when sample marking was certification, we have gone through the certification. We have the magistrate have certified that 18 numbers of polythene packs as marked so and so. It was sent to the FSL, and when the matter was received by the FSL, it was sealed, and the marking is exactly the same. Am I making myself clear, Your Lordship?
Yes, what you mean is those samples were sealed.
Those
And-
samples that was certified by the concerned magistrate. We have
Where
gone
is
through the
that?
certification.
Where is the evidence that sample was made before the magistrate?
Sample was, Your Lordship, I'll take Your Lordship kind attention to.
Because inventory is certified, but sample? The application is there,
Yes,
that you have shown.
yes. Your Lordship, if I may take Your Lordship kind attention to page number 21. This is the examination of the case IO. Page number 21, this is the cross-examination. 14, I prepare inventory for drawing sample.
I prepared inventory for drawing
Drawing
samples.
sample, yes. So,
Inventory was made.
it was exhibited. Sample was drawn before the magistrate.
Where is that? It's okay, his statement is there.
That's exactly what I was pointing out, that it was missed.
Because 121, of course, the application was there. You see, the permitting and allowing, certifying. Okay, certify the iman.
Your Lordship, in 11 page, serial 11 in the same page, it is a fact that there was no civilian witness at the time of sample drawn before magistrate. So, just that there were no civilian present.
But
then
these
it
are,
was-
okay, these are all in the cross-examination.
Yes.
So what you mean to say, this shows that sample was
Was
taken
drawn
before the
before the-
magistrate.
Your Lordship, page number 19. I was skipping too many things, so I'm going back.
It's okay.
Page
19.
number 19. This is the examination in chief.
Was, okay, paragraph 4. Drawing of sample packing and sealing of seized article was also done before the magistrate in presence. Okay, paragraph 4.
And I'm going straight to the, I went straight to the cross-examination because I want to show that in cross-examination it was intact. So the correctness of the inventory is there, certification is there, and then it was the sample sent from the inventory that was received by the FSL and from the test report that is exhibited before the court.
That was on 3/11.
Yes.
It was received on 3/11.
3/11 after 5 days. After 5 days. 3/11 after 5 days it was received. But then I was just trying to point out, it seems there is no evidence on record to show that the whereabouts of the vehicle, admittedly, the seized articles on that given date. But then what I'm trying to point out is that my learned friend have already pointed out that there is no record to show that the whereabouts of this seized article on that given date. But then what I would like to point out is that what is exhibited before the court shows that the seal was intact. And it was the same sample that was drawn before the magistrate that was received by the FSL and tested.
But that only the ground that seal was intact. Will it suffice in showing the safe custody through these days?
Yes, if it is safe, then
there is a seal number also. There is a facsimile.
Your Lordship,
that
mode,
is
yes, in page number 128. May I read, Your Lordship?
There
Mode
has-
in which parcels found to be packed on receipt of description of sale. The parcel consists of 18 exhibits packed in polythene packets.
where you are reading 128.
128.
Mode in which parcel
parcels
found.
to be packed, yes.
The parcel
This
consists
consists
of
of,
18 exhibits
18
packed in polythene packets and enclosed in a paper envelope sealed with
With wax
wax
seals and
seals,
seal
the seal
corresponding to the
impression.
forwarded. Now, Your Lordship, admittedly, on the evidence on record, it shows that during that time, the COVID-19 pandemic was prevalent in the state of Mizoram also, with the presence of the VLTF, Village Level Task Force. So, that 29th day is a Friday. So, we can understand that with, on a Friday, inventory and sample drawn was finished. Now, Saturday and Sunday being a holiday here in Mizoram.
Saturday was a holiday.
Saturday and Sunday is a holiday.
Or both the days.
Yes, provided plus COVID-19 was prevalent in that, and then on Monday, on Monday if the case is proceeded for if the file is moved, we can understand that supposing if the file is moved, we cannot make an inference. It should be based on record. I understand that. But then I'm just trying to point out that during the COVID-19 prevalent in the state of Mizoram. Now, on a Friday that thing was done, inventory, sample drawn, etc.
That was 29.
29.
29 of October.
Yes. And on Wednesday, it was sent. It was received by the FSL. If they give authorization to whoever is concerned to go to ISOL, then the next day when they proceed, and then the next day if it is received by the FSL, I can understand that even though it is not on record.
Nathial is how far from, and the FSL, the laboratory is in Aizawl.
Yes. There is only one laboratory here in this whole state of Mizoram. It's in
Aizawl.
Yes.
And so from Nathial is how far from?
Your Lordship, I am not very sure because I haven't gone to the place, but then from my learned friend's submission, it's about depending on the road condition. If it is a good road condition, it's about 5 hours drive. But then my as of now, as of today, the road condition is not good, so they used to take the whole day.
Anyways, that will not take 3 days or 5 days.
Yes, that will not 3 days or 5 days, but then the standard procedure 1 of 88 have stated that it has to be dispatched within 72 hours after the sample is drawn.
Now, what we have to see is whether it is the same seizing material which has reached.
Same seizing
Huh.
material. So, what I have pointed, admittedly, I admitted the fact that the prosecution has failed to establish as to who was in the custody on that 5 fateful day.
It was handed over to a constable, I think.
Yes, a special head constable. And Your Lordship, what I would like to stress is that irrespective of that, we can see from the exhibit what was exhibited before the court, what is here before our eyes in written black and white is that it was the same sealed packet received in sealed by the FSL, intact.
Okay.
And Your Lordship, now coming to that, since proving the guilt of the involvement of the appellant, now in NDPS case as a special act, there is a reverse burden of proof which we all are aware of.
But first you have to establish the foundational facts.
Foundational, the case beyond, yes. Now, in my humble opinion, the prosecution has established their case beyond reasonable doubt. And the defense, the present appellant, was afforded opportunity of being heard before the learned trial court by 313 and adducing evidence. Now he have 3 witnesses. But his witness is DW number 1 is a friend of the appellant, and 2 is wife, and 3 is
Those are not
brother-in-law.
very relevant.
It's immaterial.
But only to the extent that he had hired the vehicle on that day and he went to Natia.
Yes, just that. But then 313, if I may take Your Lordship kind attention to 313.
313, of course, he has.
Question number 9. Question number 4.
Question number 4.
This 313 of the co-accused was acquitted.
No, that is not required.
But
Page
I want
number
to
9.
refer to, yes, Your Lordship, I want to refer to page number 7 first. 313. Question number 4. It is also an evidence that your vehicle was parked on the right side, on the roadside of National Highway. You and accused so-and-so were sitting inside the suspect vehicle. Accused so-and-so kept a big bag rucksack on the floor between his legs. Have you anything to say? It is correct. In fact, so-and-so actually carried the rucksack. I have no knowledge about the seized articles. So in page number 9, Your Lordship.
He said that the bag was given by someone else.
Your Lordship, question number 4. It is also in evidence that the suspected vehicle was parked on the roadside of, same question. It is correct to some extent. Even the rucksack belongs to me. I only keep on the floor, not between my legs. Just that, not between his legs. It is in evidence that the bag rucksack was searched in the presence of civilian witness and recovered so-and-so. Have you anything to say? It is not correct. I was not present at the time of counting of the seized articles. Question number 9. Question number 9. Do you have anything more to say? First is in vernacular language, but then it is translated in the later part.
I deal with tobacco.
Yes.
It's in.
I deal with tobacco, and I used to purchase eastern part of Mizoram at the rate of so-and-so, and I used to sell at this rate of so-and-so. On this occasion, I visit Natia to give tobacco sample. At first, I do not know the seized article was drugs, and the same was given to me by so-and-so of Natia, whom I know him as Tingzang village. And I also used to purchase tobacco from him before. Once he sent me 2 bags of rice for his children at Mongkon Aizol, and his children had collected from my residence. Further, in the instant case, I felt pity towards the co-accused, my brother-in-law, who has no knowledge regarding the seized articles. So he knows the seized articles.
And he said that it was given to him by someone else in Nathia. He did not say in Aizol, because he was coming from Aizol to Nathia. So there is a discrepancy. I mean, he was caught in Nathia.
Yes.
And he said the bag was given to him in Nathial. That is not believable.
Yes, Your Lordship. And Your Lordship, he have admitted, he's kind of like admitted. Now the reverse burden of proof is there. Now in 313 he have made a hook for himself, saying that he felt pity towards his brother-in-law who did not have any knowledge about the seized articles, which we can infer that he have knowledge, conscious knowledge of the seized articles.
Yes, he has knowledge, but again I think under 313 whatever he says, he has to place some proof on this.
Yes, yes, but he failed to do so.
He did not do.
He did not do,
That
but
it
in
was-
fact, on the contrary, per contra, the prosecution, on the last line, on knowing the conscious position, can prove that, first of all, contraband items is said to be moved from so and so place, if information was there, and then even though it is denied by him in the 313 at some part, but then admitted on the PTE towards the prosecution have established that their case, that he have conscious possession of the seized articles, and
He admitted the bag was with him.
yes, first.
He admitted. Only thing he did not admit is that counting of seized articles.
Yes,
I was
counting
not
also,
present
yes.
at the time of counting of the seized articles. Right. It is also in evidence that in your know. So as far as his carrying the bag with the drugs are concerned,
Yes.
he in a way admitted this.
He in a way admitted, which is also admitted by the co-accused in the 313.
Hmm.
He have stated that the co-accused actually carried the rucksack, and I have no knowledge about the seized articles. And in fact, to prove that the 313 of the co-accused who was acquitted, the present appellant have stated that he have no knowledge of the seized articles, but then he have knowledge of the seized articles.
Yeah.
Now the reverse burden of proof will be on the onus of proof will be on the appellant to prove his innocence before the court. Now, Your Lordship, considering the nature of offence that is committed and the impact that it has on the menace it caused to the people at large, my humble prayer is that to uphold the findings of the learned trial court and upheld the conviction of the appellant.
That is all?
Yes, Your Lordship.
My Lord, I just want to reply some of the arguments raised by the learned additional PP, my Lord. Now, my Lord, from the evidence on record, my Lord, is very clear that no samples were drawn before the magistrate. That is very clear. And no photographs were taken before the magistrate. So how can we
Barring
know?
the statements of the witnesses.
Pardon, my Lord.
Barring the statement of witness,
Yes,
witness
yes, my
said
Lord.
that I
Now,
have
if the case IO had said that the inventory was done before the magistrate and samples were drawn before the magistrate, then photographs were taken, it is his duty to exhibit those documents, my Lord. Now there is no exhibit, there is no proof, nothing is there, my Lord. So the only thing that was done in compliance of section 52A was that inventory was done before the magistrate. And my Lord, how can we believe that, now can we know that the samples that were sent to the FSL was the articles which were seized from the appellant, my Lord? And the FSL report is not the conclusive proof of evidence, my Lord. It cannot be conclusive proof because the FSL, the assistant director who had prepared the report, he was not produced as a witness, my Lord.
Now, according to you, whether the same articles has reached the magistrate, what you say?
Yes.
That is the one night of 26.
On the night of 26.
On the night of 26, you have doubts whether the same articles were there in the Malkhana.
Exactly.
Whether it reached the magistrate.
On the 27th.
27.
Yes.
26, what is the time when the articles were seized? Afternoon, morning, what?
It's in the afternoon, my Lord.
It's in the afternoon.
Yes.
And then they had done all the procedures,
Yes.
took it to the police station, and that will take around, so only the night, evening and night of 26 which you
Yes.
are in doubt.
Yes.
And 27 it reached.
27 inventory was done. And the seized articles were sent to the FSL on the 29th.
Yes.
2 days after
27
inventory
it
was
was
done.
all done.
27 inventory was done.
Inventory was done. And then,
No explanation about the whereabouts of the seized articles on the night of the 27th and the whole day of the 28th. It was only forwarded to the FSL on the 29th, 2 days after inventory was done. And
the requirement will be like sample to be taken before the magistrate.
yes,
And then immediately sent it to the FSL.
it's a,
So
there
on
is a,
27th itself, they should have sent it to the messenger.
yes, my lord.
But
Even-
from 27 to 29, it was kept in the Malkhana again.
There is no explanation at all, my lord. The case I have not made any statement with regard to that, my lord. Even
Only-
if they have sent it on the 29th also, my lord, then it reached after 5 days, my lord.
What happened on 28?
No explanation at all, my lord.
Then 29th it was
29th,
sent.
it was sent to the FSL. It reached the FSL after 5 days.
Three,
And the
third.
special messenger, the head constable who had actually delivered the seized articles, the samples to the FSL, he was not examined as a witness, my lord. At least there should be some explanation, my lord, because the chances of tampering the evidence and the proof of the samples which were drawn and the samples which were delivered to the FSL, how can we know that it's the same
The
samples,
only
my lord?
argument of Mrs. Mary is that it was sealed,
Yes.
and in the FSL report also it is
Yes,
said that
yes.
they have received the sealed
Yes,
covers,
yes.
with the seal cover.
Yes.
The seal is, there is no evidence that seal is tempered.
But nothing is there, my lord, in the evidence of the case IO, my lord. It's only from the report of the FSL, my lord. But the report has to be proof, my lord. No personnel from the FSL were examined as a witness, my lord. Whether they have actually delivered and the report is, they have conducted the test and it contains the so-and-so.
That will not be fatal. Report is exhibited.
Report is exhibited but my lord, the mere exhibit of the report is cannot be a conclusive proof of evidence, my lord, because at least one personnel from one officers from the FSL can be produced as a witness, my lord. And my lord, even if these which questions I have raised, which arguments I have raised, may not be during the cross-examination of the case IO, it may not be brought up during the cross-examination of the case IO. But my lord, these are whether this non-compliance of section 52A and all, it can be, it's a question of law that can be raised at any time, my lord. Because it has prejudiced the appellant and it has vitiated that whole trial, my lord. So
Although not placed in cross-examination,
yes,
same will not
it's
have
a
because
question of law,
point.
my lord. Whether it has prejudiced the appellant and whether it has vitiated the whole trial, my lord. So it can be, if it's a question of law, then it can be raised at the appellate stage also, my lord.
What do you say on the or part? 52A?
52A, my lord, I have produced judgments of the dishonorable court, coordinate bench of dishonorable court and the apex court as well, my lord. And the application was made for all the 3 prayers, my lord, but only one was compliant, my lord. And my submission is that, my lord, the main point, the most important fact is that whether the samples were drawn before the magistrate. Inventory was done, that it's an admitted fact, my lord, I have no doubt. But whether the samples were drawn before the magistrate, that is very crucial for the case, my lord. Because with no explanation regarding the safe custody of the samples and all, whether the samples were actually drawn before the magistrate, my lord, that is very crucial, my lord. So it's a burden, even though there is a reverse burden as per the act, my lord, the foundational facts has to be proved by the prosecution. Then only the burden will shift to the appellant, my lord. Here, my lord, the foundational facts have not been properly established by the prosecution. And my lord, regarding section 42, whether section 42 or 43 will apply in this case, my lord. Before I come to that, my lord, I just want to raise one contradictory evidence made by the prosecution, my lord. At page 15, my lord.
Actually, the provision for taking samples
Yes.
for testing is not there in the NDPS Act. 52A talks of representative sample.
Yes. Here
And
also
it
only
is- And it is I'm told it is a practice, it has become a practice that taking of sample for FSL also comes under this.
Yes,
This is what the practice
yes.
which is followed, I'm told. But otherwise, you see the strict the words of 52A, that is subclause C of subsection 2, or clause C of subsection 2, is allowing to draw representative sample of such drugs or substance in the presence of and certifying. So it is only you take representative sample and you destroy the other rest of the drugs. That is
Exactly,
the
madam.
purpose.
Here
But-
also, only representative samples were
But
only.
taking sample for FSL,
Yes.
like in duplicate, triplicate,
Yes,
that is actually not provided in the Act.
yes, my lord.
And in the Kasif case, which has come very recently, the Honorable Supreme Court has also not dealt with this. Only said that 52A is meant for representative sample.
Yes. Here also only representative samples were sent, my lord. Only 180 tablets were sent.
Then
Page 15, my lord.
15 of the paper book.
15 of the paper book. This is the evidence of the Caesar witness, PW2. Page 15, in the cross-examination, my lord,
Yes.
at point number 5, my lord.
Point number?
5. This article was taken out by one police personnel named RTF from the suspected vehicle. So it is very clear that the seized articles was not taken out by the appellant himself. It was taken out by the police. So search was conducted inside the vehicle, my lord. So now this contradicts the evidence of the seizing officer, my lord. The seizing officer has said that the appellant had taken out the seized articles himself. But the Caesar witness has said the police personnel had taken out the seized articles from the vehicle.
What about the what about in examination in chief? What did he say? We stopped the said vehicle and asked to. This is who?
This is
the
PW2.
Acha. And asked for showing the permission. They could not produce when he tried to so and so. 2 persons inside the vehicle. Police requested us to witness the search. There was one rucksack on the floor. Police told them to get out from the vehicle, and a said bag was also taken out.
Yes. But he had not stated who had taken out the bag, my lord. In his cross-examination, he said the
On the
police-
roadside, the police told the accused to open the rucksack, and opening so and so they got. Now, whether it was taken out by the arrested person or by the police, in cross he said, seized article was taken out by one police personnel.
Yes.
But I
His-
mean,
his evidence is
whatever it
contradictory, my lord.
it will not matter.
Yes,
Because
but
seized,
I just-
Caesar, if it is inside the vehicle, inside the building, then only 42 will come.
Yes.
If it is outside the vehicle, otherwise, okay, bag was taken out by whoever, doesn't matter. But then Caesar has taken place outside the vehicle, in the public place.
With regard to that, my lord, I just want to place one judgment of the Honorable Apex Court, my lord. Here, my lord, what the Apex Court has said that even if the seizure was made in the public place, if the registration of the vehicle is a private vehicle, then 42 will come instead of section 43, my lord.
Acha, show me that. Which paragraph?
Para 14, my lord. May I read, my lord?
Yes.
Para 14.
Yeah.
The evidence in the present case clearly shows that the vehicle was not a public conveyance but was a vehicle belonging to accused Gurdeep Singh. The registration certificate of the vehicle which has been placed on record also does not indicate it to be a public transport vehicle. The explanation to section 43 shows that a private vehicle would not come within the expression public place as explained in section 43 of the NDPS Act. On the strength of the decision of this court in Jagrat Singh, the relevant provision would not be section 43 of the NDPS Act, but the case would come under section 42 of the NDPS Act. Here in my case also, my lord, the vehicle was a private vehicle belonging to the co-accused. So section 43 cannot come into play, my lord. It will be,
What
42
is,
will be attracted, my lord.
yes, they have referred to the explanation of section 42. Just see. 43 explanation. For the purpose of this section, the expression public place includes any public conveyance, hotel, shop, or other place intended for use by or accessible to the public. Includes any public conveyance. But here not only public place is there, but transit is also there. The opening words of 43.
Yes, it's there, but in this Bhuta Singh, the case which I've relied here also transit is there, my lord. It's the same facts, my lord.
Okay, I'll look into this. Then?
And regarding violation of section 42, my lord, I would like to reiterate the judgment of Karnal Singh. In Karnal Singh judgment at para 35, my lord, it's clearly said that even if there's a delay in entering the information, my lord, it has to be complied, my lord.
But what Learned PP said that in Karnal Singh, there was no GD entry at all.
My lord, in Karnal Singh, there were two conflicting judgments, and it was referred to the larger bench. And their conclusion is at para 35, my lord.
Paragraph 35 of?
Para 35 of the judgment, my lord. It's a constitution bench, my lord.
Karnal Singh?
Yes, my lord.
You've given a
Yes,
printout, right?
yes.
Yes, I've got it. Karnal Singh, paragraph 35.
Paragraph 35, my lord. In fact, the relevant portion is in the last page, my lord. This is the
Yes.
conclusion of the constitution bench, my lord. At B, sub number B, my lord. But if the information was received when the officer was not in the police station, but while he was on the move, either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action as per clauses A to D of subsection 42(1), and thereafter, as soon as it is practical, record the information in writing and forthwith inform the same to the official superior. In the instant case, my lord, this was not done. I admit the fact that he already left the police station and he was on patrol. But my lord, it is the duty of the seizing officer to record the subsequent information in writing and forward it to the...
But see, in the FIR he said all this, that I have done this, and then I have reported it to the superior officer.
That is with respect to the first information only, my lord.
No, I'm talking about the FIR, where he has also said about the second information. See, he said, right,
108.
in the FIR, then see the last line. I took seized item and owners to Natyal police station and submitted a written report to the OC. That means that included both the informations.
My lord, if you will see the information written down by the seizing officer, page 95. This is the one which he had forwarded to the officer in charge.
Yes.
At least he could have written one more line that he had received subsequent information and so he had seized the articles. But nothing is there, my lord. So it's clear that
this is the first entry.
Yes. But hereafter, nothing is there, my lord. So this is in violation of the judgment of the Apex Court, my lord. Even if there is some delay, my lord, he could have explained in his evidence also.
In fact, I wanted to see the GD entry. GD entry is not there.
Yes.
The GD, the general diary is also not there. The case diary is there, but then the entries made are not there.
So, my lord, to conclude my submission, my lord, considering all the grounds I have raised and all the judgments I have supplied to your lordship, my lord, this is a fit case to set aside the impugned judgment and order, my lord.
Okay, I'll consider. That is all?
My lord.
Okay, hearing concluded, judgment reserved. This is a regular appeal? Not-
My lord,
yes.
regular appeal, yes. I'm obliged.
Not required, I'll take it out from this. You can take, this is the very records and this, you give it to my chamber, no? I'll try to finish it today. These are other copies. This is my note, let it be here. Yeah, okay. Right. Oh, this is also this one. Oh, what? This is not. Kuldeep Singh, I've written something. Okay.
Hearing list, item 9.
Acha, yours. Acha.